So we've been abandoned by some of our colleagues, predictably. Like most forms of abandonment in the world are all too foreseeable.
Especially with spring break.
Uh, So before we get back to the subject that we were discussing, the actual content and method of the construction of alternatives and its relation to legal thought, let's discuss a little bit the papers and the way we'll organize this after the recess. So if I could, let me go around the room and see if I can persuade some of you to sign up for soon after the recess. The disadvantage is you don't yet have a polished product, but the advantage is the earlier there's a collective discussion of your plan, the more useful to you. So let's start with you. What's your name?
Some called Botnigar. So it's S-A-N.
F-A-N?
S in star.
S-A-N?
Yeah, S-A-N-K-A-L-T.
K-A-L-T,
Yeah,
okay.
P as in Paul, yeah. Some called. And I'm interested, should I give a brief?
Yes,
Okay,
yes,
great.
tell me, give us a brief
Yeah.
preview of your possible topic.
Sure, yeah. So I supervise a team of law students here at HOS and also at Northeastern School of Law in looking at taking for granted practices of legal education, so briefing, outlining, mooting, and journaling. And I look at them in particular as entry points into the kind of Langdellian worldview that sees law as a kind of narrow technical instrumental.
Now, by the Langdellian worldview, you mean Langdell's case method?
Well,
What do
everything
you mean?
infused into the ethos of American legal education. So not only the case method, but like the kind of the status of grading, the status of like displacing mooting, for example, from classrooms to extracurricular activities, etc. So I look at that, and there's two kind of possible approaches in my mind. One is in terms of a paper here. One is to kind of recognize what is anomalous in that Langdellian worldview, like what basically, what is unusual about the worldview as it leads its law graduates of the past 150 years roughly towards seeing cases as objects and not worlds, towards not worlds, as opposed to, so like an object that can be infinitely optimized and moved around in a kind of narrow technical scientific way, as opposed to a world that can be disclosed. Other aspects of that worldview might be that it leaves arguments to be seen as technical rather than historical arguments. And it sees questions either by a panel of judges or inquiry into a particular case as epistemic and not ontological. And so this is like, for example, Pierre Schlag talks about like hiding the ball. The work that it does in the background is it reshapes a law student's view of what the law is from ontological questions into epistemic to technical to instrumental questions that are only meant to use.
Or rhetorical questions.
Sure, yeah.
So from a comparative standpoint, one of the things that's most striking about American legal education is that very little law is studied in the law school.
That's right.
So the law is studied at the end in these memorization efforts, like the bar review courses.
That's right.
And studying for the bar review. And the main object of study seems to be the mastery and deployment of a rhetorical apparatus.
That's right.
It's how to spot issues, how to argue about things. What's the range of rhetorical moves that one is supposed to master? And these traditional law exams were mainly about that. They tested your proficiency in that. The point was not to establish the right answer, but to show that you were proficient in the deployment of this rhetorical apparatus. That's not done anywhere else in the world. That's a peculiarity of American education, legal education. One of its practical consequences, which I observed in an early class of ours here, is that the students graduate with a feeling that they don't know anything, since this rhetorical stuff is rather evanescent. intangible. And that then becomes one of the reasons why many of them feel that they must go to work in these law firms, big law, because that's the only way in which they'll learn how to practice law.
Sure.
So from that, is that part of what you would address, or what's the?
Yeah, so I think, one concrete answer towards going through a series of case studies into cases that don't quite fit the Langdonian model of both explaining and justifying reasons for outcomes of them. So thinking like at a high level, like Supreme Court cases like Wisconsin v. Yoder, and what actually was argued in the oral argument that laid bare kind of history of persecution of the Amish way of life that then was being kind of overwritten by narrow butts and seats mentality of the state legislature, school requirements. But so things like that, to use cases as like little touchstones for pointing out what forms of argument don't fit into that Langdonian worldview, and therefore remain inapplicable or inaccessible to graduates who hold on to or read into Langdonian worldview throughout their career. So it intended to be a kind of
But in a way, you accept the premise that the object of study should be this rhetorical apparatus, and you're protesting against the exclusion from the rhetorical apparatus of certain categories of argument.
That's right. Yeah.
Rather than rebelling against the whole idea of not studying law, which after all, would be the first order objection to what goes on in university law.
Yeah.
So are you willing to do this after the recess?
Yes.
In the week after the recess?
That's great. Yeah.
Okay. Now, could you give us your name, please?
Yeah, I'm Jessie.
Say that again. Could you
Jessie.
spell it?
Jessie.
A
Jessie.
E S S I E. Jessie.
Jessie, yeah.
Okay.
So my project will be a comparative study on agricultural production, especially the industrialization of agricultural production in the US and China. So I want to analyze the process of from individualized family farming to large-scale modernized agriculture production in the two countries, and to see how,
In the United States and China.
and to see how, like, different forces, like, especially focusing on, like, knowledge economy, that play during this process.
Okay, very interesting. So let's see what all the topics are, because I think we should group the topics. So a certain kind of topic is in one session, and another kind of topic in another. Yes,
My name's Ben Sefton,
Ben, yes. And your last name?
Sephdton, Sefton.
Yeah. Yes.
And I'm planning to write about basically applying the themes of your course to housing law and housing justice, which is what I focus on in my clinic at Harvard Law. So asking what the role of a jurist can be in trying to implement structural change in the housing system, trying to look at and critique like certain doctrinal dogmas that housing law has operated under, so in terms of contract law and property law, and looking at ways in which the law can be leveraged to implement like alternative or maybe creative models, which could make some kind of incremental or marginal progress towards
So
structural
your
change.
project could go together in the same session as Jesse's. It's the same kind of project.
Probably, yeah.
Yeah. Very good. And you?
My name is Karina Satya, K-A-R-E-E-N.
C-E,
K-A-R.
I'm sorry.
K-A-R.
K-A-R, okay. Karina,
Yeah, Karina.
okay. And what are you thinking of writing about?
So
Remind me.
I'm planning to write on, I'm trying to do a comparative analysis on the nature of democracy in India and America, and how they can create a more high energy, empowered democracy.
Yeah. And you're writing about something similar, right, in relation to religion?
No. I am, yeah.
You are, yes. So the two of you might go together, okay. Very good.
I'm Dylan Roach, D-Y-L-A-N. I'm writing about the kind of self-interest of the legal profession in pursuing purposivism, the idea that, you know, in their role in kind of essentially retroactively describing the settlement of social forces, to what extent is that due to the way that they've benefited from that settlement and have been the ones, in many ways, writing the settlement as governmental elites, and how that might change as the kind of legal profession perhaps loses some of its luster as, you know, lawmakers are increasingly from business backgrounds and other backgrounds rather than lawyers, and as we see in the horizon, things like AI and other advances that might threaten the position of the legal profession in the future.
And someone else is writing a paper about AI and law, which would go very well with this. And it might also go with your project. You, I remember your project.
Yeah, so I want to work on basically religious nationalism.
And your name again?
Kevin.
Kevin.
Yeah. So I want to work on the current religious nationalism in India and trying to look at how to articulate constitutionally to pose federalism as a way in which alternative futures can be imagined, and to use the ideas of democratic experimentalism to empower the people in a real way as opposed to in this fantasy way that the religious nationalists fantasy and kind of past-facing way in which they are constructing democratic agency. So going from your ideas in democratic experimentalism and pragmatism, etc., I want to, just present an alternative constitution.
So obviously you should go together with Karina in the same session. And you?
So my name is Tim.
Tim,
I
yes.
will be writing on the attempts of liberal governments in Eastern Europe, so Poland and Hungary, who attack the judiciaries and challenge their independence. And I will analyze the response of the European institutions and the academics who are trying to use human rights and reinterpret them to cover judicial independence, so to protect judges.
Reinterpret?
Human rights of judges as individuals, to protect them as judges as holders of power. Basically
Surprising, yeah.
so to use their right to privacy to protect their independence, basically. For example, and I will first try to find the origin. How did this come about? Was it just path dependence, or was it a strategic move by the judiciary in Poland to externalize this conflict to the European level? Because now it's the European Court of Justice that is trying to protect Polish judges through EU fundamental rights scheme, and then I'll criticize this as an instance of
So
national-
defending the judges as individuals rather than as judges in a way. I mean, it seems that the defense of judicial independence is just a byproduct of their defense of their human rights under this
Yes.
view.
Yes, but now there is a strategic litigation going on in the European Union, and they're trying to allow judges to have standing as individuals to challenge any legislation which interferes with judicial independence. So it's no longer a structural conflict between the three branches, but a vertical relation between the government and the judge, who is just this poor guy whose privacy is
Yes.
violated. So.
And you?
I'm Trace, T-R-A-C-E,
Yes.
and my topic is pretty wide ranging, I think. First, it'll seek to establish sort of what the purpose and function of law is, like legitimate normative goals of law, in this, and in sort of this theory, it sort of draws from Plato and Aristotle, sort of Greek traditions of dignified life as being sort of the aim of a body politique and therefore law. And then I'll turn from there to talk about law's role in structuring political, economic, and social life. I think that'll be big, but we'll think about political in terms of political rights, economic in terms of economic rights and market relations, social in terms of the role of distinctions and how they're used to, allocate advantage and disadvantage in a given society. So in that sense, it'll sort of try to relate market state and state and society together in sort of this understanding of everything being interconnected, and obviously ideology, culture, and stuff comes.
It's very
into-
ambitious, obviously. We should wait for
Yes.
another project of
Yes,
similar
this is
scope.
it's pretty ambitious, but it gets bigger too. Don't worry. And then from there, it'll think about theories of law, sort of touching back to that initial dignified life as a normative goal in the role of the jurist, and specifically the role of the jurist in constitutional interpretation and structuring society in that way, and sort of the pressures or tensions between notions of fixity and contemporaneous consent, and sort of it'll promote what I think is a pragmatism in the end, which is subject, I think, to a significant critique of jurists and technocratic elitism and that sort of thing, and expert rule, and I'll have to come up with a defense of why. I think that's a very strong critique, and I
A
think that-
defense of politics against technocracy, is that what you imply?
No, I think I haven't written it, right? So the claims are not fully teased out. But I think that in arguing against, it'll present a vision of politics, society, and economics that kind of refuses to or condemns ideology and favors pragmatic rule. And in a pragmatic rulership that's informed and reasoned, there's the selection of the rulers, and I do think there's a robust critique there in sort of the rule of the technocratic elite, as opposed to what you might call more chaotic change driven by the groundswell of people and.
But is it in favor or against the technocratic elite?
I think it will seek to be both, which is a very challenging needle to thread. And I'm not sure I've reasoned it all out. But I think in its criticism of ideology and the work that ideology often does in society, and whether it's polarization, whether it's frustrating civic ties and civic discourse, whatever it is, unwillingness to compromise and whether, there's theories of conservatism that it's like incremental gradual change, right? Like Burkean conservatism.
Yes.
And I think ideology poses substantial barrier, and you could, in the American context specifically, you could argue that the Madisonian constitutional vision isn't about gridlock, but it's more about compromise and incremental gradual change than roadblocks. And ideology frustrates the function of that fundamental organizing principle.
Well, there's no contradiction between roadblocks and compromise, because one idea is that the roadblocks are there to prevent politics from going off the rails. That is,
I think-
politics should be about compromise
Yeah, I
and
think
not
the-
about systemic ambitions.
Yes, I think, but I guess one of the arguments is that like incremental progress can be a progressive vision. And like it is additive and it is slow and gradual, but it can, when taken together over time, if constantly pursued, it can affect systemic transformation.
Yes.
And so that's kind of, that's getting a little more into the weeds of some of it, but it's a big project. I don't know how long it'll be, and I could use your help on some sources
Sure.
and things, but.
So what should we do? Where should we begin? Maybe we can, your discussion can be the first, is that okay?
Sure.
And which should we do with you? Should we do yours?
Mine?
Yes,
Yeah.
yes.
I'm happy to.
Okay, so why don't you go with Sankal?
What day is that's the
That would be the week after the spring recess.
21st?
Because we don't have that many weeks. We have, the last week I want to preserve for going back over the themes of the seminar. So, this would be the week of, this would be on the Thursday, the 21st,
Great.
right?
Would come with like you'd come with paper or the presentation or a draft?
No, I think the idea would be to talk like about 10 minutes
Yeah, okay.
and present your ideas, and then we'll have a conversation.
Perfect.
The same thing with yours there. So those, at least both of those would be in that session. We could also do the two India ones in the same meeting. You want to do that? You want to do that, Karina?
I will have a brief due, brief due that week. So I
You
will
have a what?
I have a 1L legal research and writing brief due that week, so I would prefer to be the next week.
What week?
Okay.
Sorry?
What week is it due?
It's due on the 25th.
Oh, the 25th.
Yeah.
So you'd like to do your presentations on the 28th?
Yeah, that would work for me.
Is that good, the 28th? Okay. And I'm just thinking of yours on China, where, which session to place it in. Do you have a suggestion? Having heard these initial presentations, what to group it with?
I could go with Ben's for,
With Ben?
yeah, during the first one, right? For the first one,
You think that makes sense?
yeah.
Are we doing more than 2 per day? Because
Yeah, I think we can do more than 2 a day, sure. So the 3 of you then on the 21st.
Great.
Now, where should we put you?
I can do the 28th or after. You said there was someone else doing about AI. There's kind of-
AI, yes, the AI person.
Yeah, so really anytime except, I couldn't do the 21st, but any other Thursday I could.
Okay, so the 28th?
Yeah.
So I'm happy to do 21st as well, but I do wonder if it would be a worthwhile contrast to present on the day that a couple of folks who have AI focused works could go. A lot of my work rails against the increasing use of AI. That's all.
Well, I have to find the other person.
Oh,
Yeah.
up to you, yeah. I figured might be more like it, yeah.
But you don't want to do it on the 21st, right?
I can't do it on the 21st.
Yeah,
It
so
could be whenever, wherever.
just stay, we'll just stay
I'll
on
stay.
the 18th.
Sounds good.
We'll do it another time.
Sounds good.
So on the 28th, we would do the two India presentations, right? No, I'm sorry, I'm getting confused. You don't want to do the,
20th I think is fine.
what?
20th is fine. 21st wouldn't have been okay.
28th?
Yeah, that's fine.
28th is okay, right? And I think in a way yours goes with the India presentations, don't you think?
Yeah.
So we could do you on the 28th as well.
Okay.
So 21st, Sankalt, Ben, and Jesse. And 28th, Karina, Kevin, and Tim.
I think I was there as well. Dylan, the 28th.
28th, okay. And we'll try and get the AI person in somehow. Okay, and for the people who are speaking on the 21st, if you want to discuss with me, you can email me at any time, and we can speak on the phone if that's useful. I won't be in Cambridge, but I will be accessible.
When would you like me to go?
Well, we haven't found a place for you yet because you have such a big project.
Okay.
So we have to find someone else who thinks in similarly large terms to pair with you.
Okay. Fair enough. Fair enough.
Do you have an intuition? I mean, between these two don't seem appropriate.
I don't think it would go with any
Yeah.
of the ones articulated today.
That's what I think too. So in principle, we would aim for the following week, which is,
Would that be the 5th or the 4th? Are there 30 or 31 days in March?
Do the 4th.
The 4th. I'm happy to go whenever. But,
so 21st, 28th. And the 4th then is the next class. So when is our last session?
I can.
I think it's the 18th, is that correct? So we'll keep the 18th open, so we have the 4th and the 11th for everyone else, including you. Right, so let's return to what we were doing before. So my idea was that having discussed the dominant style of legal analysis, its causes and consequences, and the position to take with respect to the lesser vocation of legal thought, which is legal thought in the professional or adjudicative setting. We then began the discussion of law in the exercise of its greater vocation to assist the citizenry, the social movements, the political parties in rethinking the future of society, the alternatives. And with respect to this discussion of legal thought in the exercise of its larger vocation, there are three issues. So the method by which it does this, And I said a little bit about the method last time, describing it in the categories of mapping and criticism. The content, giving you an example of a progressive institutional project. And then there's the question of the agent. The role of the legal profession in relation to this larger exercise. And I suppose there's a fourth question, which is, who are these alternatives for, other than just the people in general? What's the idea of the social base of this alternative? Now let me return first to this question of, and the focus, yes, last week was on the transformation of the private order. I remind you that the characteristic of legal innovation in the 20th century was to have superimposed a new law of a regulatory and redistributive state on a largely untransformed body of private law. So remember, a major contrast between the legal thought of the 19th century and the legal thought of the 20th century was the liberal theory of rights, the classic liberalism about rights. Imagine that there was a set of rights of individual and collective self-determination which had to be secured for there to be prosperity and freedom. And the legal thought of the 20th century took the position that the exercise of those legal rights was not enough, because the actual enjoyment, the practical enjoyment of the rights of self-determination depended on defeasible conditions, that is, conditions that might fail. So as in Anatole France's Canard, that the law prohibits both the rich and the poor from sleeping under the bridge. So then it became a characteristic concern of the legal thought of the 20th century to reorganize all of law as a dialectic between the rules and rights defining self-determination, individual or collective, and the rules and rights reestablishing the practical conditions for the exercise of these rights of self-determination. So, an example is the relation of labor law to contract law and the theory of economic duress in contract law. So the idea is, in the employment relation, there is massive inequality of bargaining power. This massive inequality of bargaining power threatens to turn contract into a sham, a facade. The relation may on its form be contractual, but if the worker, the employee, has no bargaining power comparable to the employer, he'll be a serf, a slave. He won't really be an independent contracting agent. And therefore, the objective began to reestablish the reality of bargaining power so that contract would be real and not just a facade. And that happened within particular legal disciplines, within contract, in the relation, for example, between the rules governing contract formation and the rules governing unconscionability. It happened in the relation between neighboring legal disciplines, like the example I just gave, contract law and labor law. And it happened with respect to the whole relation of public law to private law. As you could say, all of the new public law of this regulatory and redistributive state had that relation to private law. It said that the law of the 19th century thought that all you had to do was to cling to a particular system of rights in order to establish freedom, the scheme of order and liberty, And the law of the 20th century took the position that that wasn't enough. You had to make sure that these promises of freedom were for real and that they would not remain unkept. Now, the remarkable thing about this operation is that conceptually it seems that the question of assuring the exercise of these rights of self-determination leads inevitably and naturally into pluralism about institutions. There's always more than one way of assuring the reality of these rights of self-determination. And as soon as you focus on the plurality of possible ways of assuring the rights, you're led into the discussion of alternative forms. The example of labor law is characteristic. I was just giving labor law as an example. So there's massive inequality of bargaining power in the employment relation. How do you reestablish the equality of bargaining power? You reestablish it by allowing the workers to organize and bargain collectively. And so the idea was you do that through the collective bargaining system. That's the orthodoxy in labor law in the North Atlantic countries. But the problem is that that's not the only possible response. There's another possible response, which is the response followed in Latin America, and initially inspired by Italian fascism, and that was the corporatist labor law regime. So the corporatist labor law regime said everyone is automatically unionized according to their place in the production system, and the union system as a whole is under the tutelage or the influence of the state operating through a ministry of labor. So you have two labor law regimes. Now, take that example and just think about what that means. What that suggests is that this generative concern of 20th century law about the practical enjoyment of rights or the reality of rights could have led and should have led into the next stage, which was the exploration of the institutional alternatives. But it didn't lead. This is what's strange. It stopped there. And that helps explain how this new body of regulatory and redistributive law came to be superimposed on an untransformed body of private law, property and contract, and the law of associations. So in the discussion last week, I raised the question of what happens if we reverse this fate and we begin to do what the legal thought of the 20th century failed to do. We take this question of the practical reality of the promises of right as a provocation to discuss the alternative institutional futures, the alternative ways of guaranteeing the practical enjoyment of a right, lead into the discussion of alternative institutional futures, as this labor law example I just gave suggests. And now we can relate that to a practical issue, which is, what comes first? Is it the reformation of politics or the reformation of the private order? And here there's something else which is very interesting, which is the reformers and progressives around the world often think or say that the reformation of politics comes first, that it's the mother of all reforms. The reformation of democracy comes before the social and economic redirection. But it seems that that's not what actually happens in the world, because, as I suggested in an earlier class, no country reforms its politics and its state in order later to decide what to do with the reform politics of the state. The reformation of politics of the state only happens when it needs to happen. When it's forced by a change that is evoked or debated in this discussion about the social and economic direction. And now there's a direct provocation for that results from the change in the basis of what has been the major orthodoxy of the progressives, which is social democracy or social liberalism. And I offered a characterization last week of the difference between social democracy and social liberalism using three concepts. So one is historical social democracy, which was anticipated before the Second World War and developed after the Second World War in Europe and more generally in the North Atlantic world. And if we view it unsentimentally, what it did was it defended insiders against outsiders, relatively tenured and stable workers against unstable workers, small business against big business, incumbents in the market for corporate control against challengers. Social democracy was attacked by what came to be known as neoliberalism as being both costly and unfair. It imposed economic rigidities in the market that diminished output and productivity, and it defended insiders against outsiders. But that wasn't its main problem, this neoliberal attack. The neoliberal attack was effective because something real happened in the world. And what happened is that the base of historical social democracy in the actual organization of production began to fail. Conventional industry ceased to be the vanguard. Many countries around the world began to deindustrialize because there was a new vanguard arose, which is the knowledge economy, a new advanced practice of production. And the base of historical social democracy began to collapse. That was a world in which there were a large stable labor force assembled in large productive units like factories under the aegis of large corporations. That world disappeared little by little and was replaced by the world of the insular knowledge economy, these socially exclusive fringes that are highly advanced, based on advanced technologies and capabilities, but lock out the vast majority of workers and firms. That was a more powerful influence on the hollowing out of social democracy than the neoliberal arguments about its inefficiency and injustice. So what resulted from the combination of the neoliberal attacks with the actual failure of the productive base of historical social democracy is what we can call social liberalism. The third concept in the list: social democracy, neoliberalism, and social liberalism. Social liberalism is the reduced or eviscerated, hollowed out form of historical social democracy, which gives up most of these historical divisions between insiders and outsiders and retreats to the last line of defense, which is the preservation of a high level of social entitlements meaning in practice a high level of investment in people and in their capabilities, for example, through health or education in Europe, paradoxically financed by the regressive and indirect taxation of consumption, as through the comprehensive flat rate value-added tax. And that's the orthodoxy. So the enlightened elites on both sides of the Atlantic, in Europe and in the United States, aspire to combine European-style social protection with American-style economic flexibility. And the rhetorical instrument of this project is what I call social liberalism. Now then, if we want to think beyond, from a progressive standpoint, from a left-leaning standpoint about the alternative, we have to face immediately a range of practical problems. And the most important of these problems has to do with the insular character of the knowledge economy. It's multi-sectoral, it's not just advanced manufacture, but in each sector it appears as a socially exclusive fringe. And this insular character of the new vanguard has momentous consequences for economic slowdown on the one hand, and for economic inequality on the other hand. It slows economic growth down because it denies the most productive practice to the vast majority of workers and firms. And it deepens economic inequality because it anchors economic inequality in the divisions between vanguards and rearguards, or between the vanguard and everyone else. So that's why I said the characteristic situation of the United States. There's the vanguard, this high-tech, highly productive vanguard. The majority of the labor force is abandoned to precarious employment, and the masters of the new vanguard discover a way to bifurcate the process of production. The lucrative and creative part they keep for themselves in firms that are often fabless, as they have no physical apparatus. The physical apparatus is all subcontracted. And subcontracted to workers in firms in remote parts of the world where there is a much lower tax take and a much lower wage, labor and tax arbitrage. And that situation, that division between the vanguard and the rest, or the vanguard and everyone else, the vanguard and the rear guard, then goes in parallel to a series of problems in the relation between labor and capital, and in the relation between production and the real economy. Finance and the real economy, or finance and production. So, a large part of the labor force is abandoned to precarious employment. And unionization shrinks radically. So this doctrine of countervailing power is no longer effective. And the economy is financialized. Finance, instead of being a good servant of production or of the real economy, becomes a bad master. So then it's necessary to do what the politics and thought of the 20th century failed to do, which is to rethink and reorganize the private order, and not just to superimpose on the existing private order a new public order. And one of the tasks then is to find the way by which we can turn the knowledge economy for the few into a knowledge economy for the many, to replace the insular and exclusive knowledge economy by an inclusive knowledge economy. And institutionally or legally, I argue, that goes through a series of steps, which can begin modestly, but then proceed in a direction in which the ultimate outcome is a radical change in the legal status of the means of production. So in the proximate stage, you can say the objective is to expand access to capital, to technology, to capabilities, in favor of a much wider range of economic agents. And there are two classes of agents that are especially pertinent. On the one hand, the retrograde small and medium-sized firms of the peripheral parts of the production system. And on the other hand, the mass of individual economic agents, service providers characteristically, who have lost stable links to any business organization. So the small and medium-sized firms have to come closer to the vanguard. They have to acquire a way of gaining access to the capabilities of the vanguard. And the individual economic agents have to be transformed into what you could call technologically equipped artisans, lifted up in their capabilities through some combination of governmental assistance or support and cooperative competition among these agents, these firms and these individual people. And you could think of that in the context of American history by analogy to the agricultural extension of the early 19th century. The Americans created family-scale agriculture with entrepreneurial attributes through a combination of decentralized partnership between the government and the family farmer and cooperative competition among the family farmers. May I say, you can imagine that that idea then develops into a second stage in which you begin to formalize these institutional ambitions. A model of government-business relations which is different from the US model, the American model of arm's length regulation of business by government, but also different from the Northeast Asian model, a formulation of unitary trade and industrial policy imposed top-down by the bureaucratic apparatus of the state. It would have to be a form of partnership or strategic coordination that would be decentralized, pluralistic, participatory, and experimental. So, in other words, not one trade and industrial policy imposed from top to bottom, but a series of alternative trade and industrial policies arising through these alliances between the state and the private agents. And then the third stage, the final stage, is what I call the capital auction. So we imagine that what Karl Marx called the means of production, both liquid capital and technology, are placed in the hands of independently administered funds. And these funds operate experimentally or empirically under a number of different regimes. Different, for example, with respect to their risk profile, different with respect to the time horizon and so forth. Under the watch of the democratic institutions that observe to see what works, how it works, what the consequences are, not just for the economy, but more broadly for the society. And what then are the legal devices by which we can construct this order? So first, property. The classic law of property, the classic theory of property that comes from the 20th century places the unified absolute property right at the center. And then this unified property right is surrounded by a penumbra, by a periphery of anomalous forms of property. Disaggregated, fragmentary, conditional or temporary claims on capital. But the unified property right is still in the central place ideologically or imaginatively. It organizes the space. And you then have to imagine that eventually it will cease to be in that position. And we will begin to think of the disaggregated forms of property as the normal forms, which in the history of law, comparatively, they have been. The unified property right is an anomaly in the history of law. And the same sort of thing happens in contract. So in contract, the center on the orthodox theory of the 19th and 20th century was the bilateral executory promise. A promise for an exchange of instantaneous performances in the future, which is completely exhausted in the moment of its performance and fully bargained out. And once again, this kind of contract was always surrounded by a host of exceptions, anomalies, of which the most important is the relational contract. Not fully bargained out, incomplete, for a series of performances and exchanges in the future. Its real object not being any particular performance, but the development of the relation itself. And you can see that in these three stages I described, the transformation of the knowledge economy for the future into for the few into a knowledge economy for the many, we need both the anomalous forms of property and the exceptional forms of contract. So that's an example of, and then we need a third thing, which is a different way of thinking about the relation between public and private. So it begins in public and private partnerships, and it ends in a relativization or an effacement of the distinction between the public and the private. So that's just to suggest how the legal thought of the 20th century might might cross this frontier, which it failed to cross in the 20th century, the legal thought of the 21st century, taking the issue of the practical enjoyment of the rights as a provocation to go to the next level and discuss the plurality of forms of organization. And we can ask ourselves two questions. First, what is the social base of these alternatives? Who are they for? And second, what is the role of the jurists in the construction of these alternatives? So on the first question, the central claim is that the base, the social base of the alternatives can no longer be what Marx imagined them to be. It's not an industrial proletariat headquartered in the capital-intensive parts of the economy, especially industry. what Marx imagined to be the industrial proletariat is now what the Marxists themselves would call a labor aristocracy, a relatively privileged minority within the labor force, which is seen by all the other groups in society and ultimately comes to see itself as just one more special interest rather than as the bearer of the universal interests of society. So it's a different base. And what is this base? This base is what I propose to call the subjective petty bourgeoisie. So the majority of people in most of the countries in the world today are poor and disorganized, but their horizon of aspiration, rather than being proletarian, is petty bourgeois. What do they want? They want a little farm, a small shop, a technical service for which they can charge a fee. All of the bric-a-brac of conventional petty bourgeois life. Their dream, by default, is antiquated and isolated family business, based as family business has historically been on family saving and self-exploitation. So in the petty bourgeois firm, people work desperately day and night. That's what I mean by self-exploitation. It's not that they're exploited by the capitalists, they exploit themselves. And that's the world of this petty bourgeois dream. And there's a problem. First of all, there's a problem for the individuals that the achievement of this dream at best allows for a very modest level of survival. It doesn't go anywhere. But it's a bigger problem for society. No society can experience a growth miracle by this means, by simply indulging the hope of antiquated, regressive family business. So then the argument is, for there to be a growth miracle, two things have to happen. In the elites, there has to be a split between the rentier majority. In most countries, they're actually financial rentiers. And a productivist and nationalist counter-elite that seeks and wins power in the name of a national development project, the productivist orientation. And this counter-elite, having won power, then has to garner support in this majority of the subjective petty bourgeoisie and offer it an alternative to its default dream, which is isolated, archaic family business. A different way of achieving its ambition of modest prosperity and independence. And that then converges with these ideas about the knowledge economy for the many. It can't be just, no one is going to bring the Rust Belt industries back to life, conventional industry. It has to come in a new form, and that happens in every sector. We can't solve the 21st century problem of precarious employment simply by evoking the 20th century solution of unionization. Unionization in its conventional form is also probably not coming back. But we can't allow the imperative of economic flexibility, which is unavoidable and legitimate, to be confused with the outcome of radical economic insecurity. Because there can't be a dynamic of inclusive productivity if there's a persistent downward tilt to the returns to labor. And similarly with respect to finance, we can't allow finance to have a predatory relation to production. We want it to serve production rather than simply serving itself. Now, on this point about finance, it's important to make a distinction. And the distinction is to say, this is not a move against the speculative element in finance. Because financial speculation is useful to society in two respects. First of all, in the development of information, and second, in the organization of the allocation of risk. The problem is not the speculative element in finance. The problem is the dissociation of speculative finance from production. That's the problem. And that's what we would have to focus on in this program. And so then we have innovations in the law of contract, innovations in the law of property, innovations in administrative law that make possible this partnership or coordination between public and private. And that's a whole new legal agenda with the base that I've just evoked or described. And who's going to do this? Now we come to the question of agency. So the task is very important, but it has no agents. Because how can we expect the lawyers to do this? The lawyers are working in-house for these big corporations. They're litigating for private interests. They're going to work for big law, graduating from places like Harvard Law School and going to work for the big law firms. So there's a task, but there's no agent. And I think this begins in a premise which is almost inevitable, right? As I mentioned early in our seminar, I said, the world is organized to reproduce itself. So if you invent a transformative task and then you look around you to find who is the agent, the characteristic answer will be there is no agent. Because among the forces that exist in the present society, there's no force that emerged in order to subvert the present direction. And so the task comes before the agent has to be invented afterwards, seizing on the existing agents and using them somehow incongruously or unexpectedly. And that's the uncomfortable outcome of this part of the discussion, which somehow we have to discover a bridge between the jurists as they now exist and this task which we're attributing to them. So that's what I wanted to say by way of recalling the discussion last week. And now let me ask for your comments about this. I'm just trying to design this as a whole, because the next domain of discussion is public democracy. So this is, you could put all of this stuff under the heading of the democratization of the market, in which the most important form of democratization of the market is the creation of a knowledge economy for the many. And the democratization of the market in turn depends on the deepening of democracy. But I argued before that what comes first is the conflict, the struggle over the social and economic direction. What comes first is not the reformation of democracy, contrary to what the progressive reformers around the world characteristically imagine. Yes.
So if I understand correctly, you locate the proposed agents of change, the subjective petty bourgeoisie, outside of the global north and the wealthy Atlantic,
Outside of what?
the global north. So the
The global-
outside north So like outside
No,
of the US.
So I'm thinking of most countries in the world. I'm thinking of countries like China and India, Indonesia and Brazil, Turkey and Nigeria, the large populous countries of the world. And what is the popular majority in these countries like? It's what I said. It's this subjective petty bourgeoisie. The majority are not they're not objectively part of a small business class. They would like to be, but they're just poor. They're poor, they're subsistence farmers, they're precariously employed workers on 0-hour contracts. But what they want to join this petty bourgeoisie. That's the majority. Now, you can ask yourself, is there a counterpart to that in the rich North Atlantic countries? And I think it seems there is a counterpart. It's not literally the same, but the counterpart is the dispossessed worker, who is the basis, who is then joins the political base of the plutocratic or right-wing populace in these countries, and feels abandoned by social democracy. That's the counterpart. So the working class is divided now into two parts in these countries. There's a relatively credential part that goes to college and has certifications and specialization. And there's an uncredential part, the less educated, the less specialized. The uncredentialed working class, which experiences this dispossession, and in the United States, also believes itself to be the victim of a conspiracy between the white and black elites, to its disadvantage. The race problem is a part of this, is the counterpart. They're the counterpart of the North Atlantic countries. And in these other societies, like France, for example, would be another, there are direct analogies to the same situation. So that's what I would say. I would say there's no exact equivalent to this phenomenon of the subjective petty bourgeoisie in the rich North Atlantic countries, but there is a counterpart.
To the extent that you think that they're not exactly equivalent, do you think that some kind of, like the change that you're envisioning, the subjective petty bourgeoisie being the agent of?
Well, the
is
first
possible?
reason why it's not exactly equivalent is that for the most part, they're not actually poor. So the conventional statistical definition of poverty doesn't apply to them. Now, actually, in the United States, the average person has zero saving, no saving. If you want to know what the saving of the average American family is, it's nothing. So the average person in the United States doesn't have $600 to spend on an emergency. So by another definition of poverty, you could say they are poor. But that's not the definition of poverty that the economists and sociologists use. So there are people who don't live miserably, they don't live in shanty towns, but they have nothing. And if they have an emergency, like a medical emergency, they have no money for it. Are they not poor by some functional standard? So it seems to me that there's a counterpart. You're smiling. You want to make a comment about this?
Well, it's a little personal, anecdotal. I grew up extremely poor. Public subsidized housing in Cambridge, single mom, difficult childhood in general. There a lot of adversities in my childhood, but there were still good moments. And now my mom, she has her GED, that's it, didn't even graduate formal high school. And she works 75 to 80 hours a week between two jobs. and she makes about 80 to 90 grand. And that's not poor, right?
That's not poor, yeah.
But when you're a single woman supporting, you know, your kids, your family,
Yes.
you know, it's not you buying food, and it feels like you're always, the degree of precarity you feel is very much real, and there were definitely extenuating circumstances, you know, other stuff that I'll spare you, and the earlier part of my childhood that made things much worse, but
But on this question that your classmate there asked about the counterpart to the subjective petty bourgeoisie in the rich countries, what do you think?
I think that the vision is still, like, my mom doesn't own a home, right? And still rents, and
Yeah.
I think the vision is actually similar in
Of a
terms
poor person
of-
who would
of a
like to
poor-
be petty
of a
bourgeois.
poor person is, and maybe that's because it is an articulation of what we imagine to be, like, that's a dream of mine, right? Having grown up in those circumstances, is to own my own home and to be able to provide for my kids and give them what I didn't have. Like that is in some ways
So that's a large-scale phenomenon in these societies. So it suggests there is an equivalent, yes.
Yeah, I was just wondering, how do you know that poor people want to become entrepreneurs? What if they just want a stable job that will give them a lot of free time and enough money to run? You assume that people
So the
are
way in
very
which,
creative.
the only way in which I know, I don't know this by some kind of empirical survey. I know it by talking to them. So in my country, I go around and talk to people in all the different regions of the country. And what happens is there's the archaeology of the Brazilian society is, which I imagine is quite similar to other societies, like India, for example, is on top there's an emergent entrepreneurial class, lower middle class, you might call it in the United States, that has taken on entrepreneurial direction. Beneath them are a group of people whom we call in Brazil the batalhadores, the combatants. So they're people who are poor, they're not petty entrepreneurs, but they have 2 or 3 jobs and they work day and night. So if you go to a train station in Brazil at like 4 in the morning, the train station is crowded by these people. And they have an entrepreneurial attitude. Most of them are evangelical Protestants, so they have a theology of supersession and self-help and initiative. And then beneath these batalhadores, who are millions of people, tens of millions of people, are the mass of poor people. And the mass of poor people are divided in, the main division is they live in the periphery of these large Brazilian cities. The main division is the division between the majority who live in destructured families, by which I mean a family in which a single mother is the only provider. The men rotate as unstable partners. So the poor woman, the poor mother, has to somehow save her children from poverty, from crime, and so forth, and go to work in these ad hoc jobs, these temporary jobs. That's the majority. And then there's another group in which there is a structured family, there's a stable family. That's the big difference, when there is. And they're the ones who can benefit, for example, from skilling programs, which are generally inaccessible to the majority who are in the destructured families. So that's a situation. And I think there's a situation in which, if you take it as a whole, my narrative does apply to them. That is, their ultimate dream is to join petty bourgeois life. because that's the only image of decency, of dignity, of social protection and stability that is available to people. There's no other image, there's no other social narrative.
Which speaks somewhat to the, like, ownership, the way, like, I mean, this is sort of in the US context at least, but like property ownership is implicated or a constituent element of our concepts of self-worth and dignity.
Absolutely.
And
But
the,
this is what was said of the principal composition of the early English novel, in which the object is accumulation. Daniel Defoe, Robinson Crusoe. Why does Robinson Crusoe accumulate things on his island? He accumulates things so as not to depend on people. So accumulation is an alternative to solidarity in a society in which solidarity is impossible. That's why there's accumulation. And if there's no social interdependence, organization, social reciprocity, what's less is to accumulate things.
because with social dependence comes risk and uncertainty. And we want to resist that risk and uncertainty. If I own my home,
Of course,
I
Of
feel
course.
more
but
secure.
it depends on the level of interdependence and solidarity, right? In a society which is more solidaristic, in which people take care of one another, and you don't have the $600 to spend on an emergency, you get it from someone else.
Is that liberalism?
What?
Is it liberalism? Like, what would you point
No, that's
to?
not liberalism.
No, I mean, what would you point to as sort of the ideological or cultural phenomenon that orients us away, or is it human nature, right, that orients us away from codependence or social dependence, as you put it, and toward Whitman self-reliance, toward those visions of total
So it's a
individual
society in
autonomy.
which connection, working together for a common purpose, is an exception, is not the normal condition. The normal condition is you're on your own, and that's a condition which you can't count on solidarity. And so in the European countries, there was a surrogate for this solidarity, which was homogeneity. So the European countries were like little tribes. The people had the same religion, worshiped the same God, spoke the same language, they looked like one another. So you take a country like Sweden, it was a tribe of poor peasants that later on became rich in the 20th century. But so long as they were a tribe of peasants, poor or rich, who were alike, it seemed that they were cohesive, because then the money transfers organized by the state were an implementation of their identification with one another, with themselves. But as soon as migratory flows began to erode the level of homogeneity, the inadequacy of money as a social cement became manifest. So as soon as they're no longer like a little tribe, it's not enough. Homogeneity no longer exists as a precondition or as a substitute for solidarity.
Yeah, this reminds me of the sociological literature on, like if you just look across history, societies that are more homogenous or more equal, and societies that
Of
are more
Of course, so
diverse or
this
more
is then the
unequal.
question, so then that raises the question, what should the basis of homogeneity be in a contemporary society? And you could say, ideally, cohesion should not depend on similarity. Cohesion should depend on common purpose, on shared purpose, on doing things together. So cohesion is something you should be able to create, and not just like a fund in the bank on which you can draw based on homogeneity. But that's a more ambitious idea of cohesion.
Do you think it's the classic understanding of the diversity challenge in this way, in a diverse society?
No, the classic sociological theory of people like Durkheim was, in the primitive societies, cohesion was based on similarity, as I said. In the complicated modern society, there's functional differentiation. And so people like Durkheim kept searching for an ideological basis for solidarity that would replace similarity. And they didn't find an adequate basis.
I'm thinking of policymakers' efforts to deal with diversity, and that it's always been a binary, either assimilate or, like it's assimilate or be different, right? Like migratory patterns all to the same place, and you create your own little mini, you retain your cultural identity in that way. And it's...
Well, this is another discussion, because I would say that the roots of a human being don't lie in the past. The roots of a human being lie in the future. And we create identity. We can create identity. So a higher level, a higher ideal says our solidarity, the base of our solidarity should not be a memory. It should be a prophecy of our working together in a certain direction. That's the higher ideal. But to get there is very difficult. And it passes through all these intermediate stages. Now, I did want to add another thing. So all of this discussion is a discussion about the private order, which, after all, 20th century legal thought abandoned. And that would have to be the heart of the discussion today. But that goes together with another set of ideas about the public order, about democracy. So the counterpart to the democratization of the market order is the deepening of democracy. And there too, there's a task of institutions, of legal ideas. And because I want to say that all the existing democracies are flawed democracies. They're low energy democracies, which inhibit repeated structural change, make change depend on crisis in the form of ruin or war, and perpetuate the rule of the living by the dead. So what are the concrete institutional arrangements that would change this and deepen democracy? And there too, there's a legal task, an institutional task. So first, innovations that raise the temperature of politics, which is the level of organized popular engagement in political life. So the conservative political science and conservative statecraft are based on this idea. I was just talking about this yesterday. That at the end of the day, we have to choose between a politics that is cold and institutional, and the politics that is hot but anti or extra institutional. So we have to choose between Madison and Mussolini. And what this idea excludes is the third possibility, that there could be a politics that is hot and institutional. That the hot politics is not just Mussolini, it's not Caesarism, that it can arise from a series of practical arrangements. And what are these arrangements? They're about the rules of voting, like whether the vote is mandatory or optional, the electoral regimes, all of which have a circumstantial result. But you can't say in the abstract whether first past the post voting or proportional representation is more disruptive. It depends on the particular circumstance. So in one society, the replacement of proportional representation by first past the post voting can be disruptive. In another society, it can be the opposite. The rules governing the role of money in politics, whether politics can be financed by private capital, the rules governing the relation of the political parties to the means of mass communication, whether television time can be bought or not. So the combined and convergent effect of all of these rules determines whether or not there can be a politics that is both hot and institutional. And that is one of the institutional conditions for a high-energy democracy. Now, second, the pace of politics, because a high-energy democracy is necessarily an accelerated politics. So in the American constitutional arrangements, there's a liberal principle of the fragmentation of power. There are many sources and seats of power in the state. And there is a conservative principle of the slowing down of politics. That's Madison's scheme of checks and balances. And the Americans think, mistakenly, that the liberal principle and the conservative principle are naturally and necessarily linked. But they're not necessarily linked. They're linked by design, by intention, to inhibit the transformative uses of politics. So you can affirm the liberal principle of a fragmentation of power, but repudiate the conservative principle of the slowing down of politics. For example, under an American-style presidential regime, you might say, if there is an impasse between the two political branches, either branch would be able to resolve the impasse by calling anticipated elections. But the anticipated elections would always be bilateral for both branches. So that the power, the branch that exercised unilaterally the constitutional prerogative would have to pay the political price of running the electoral risk. And that shows how a simple institutional change can have drastic effects. And that this association of the liberal principle with a conservative principle is not necessary at all. There are many ways in which it could be superseded. Now, the third in a set of innovations has to do with the relation between central power and the power of the local, of the periphery. And the general idea is this: as society goes down a certain road, it has a strong government, makes a strong commitment to a particular path of development, it hedges its bets by allowing part of itself to deviate from the general solution and to generate a counter-model of the national future. And that's the experimentalist idea. So the experiment is only powerful if it's tangible. It can't just be a doctrine or a proposal. It has to be exemplified in the country. So part of the country takes a different road, and it exhibits that different road to the whole country. So the first stage is cooperative federalism. cooperation is the most powerful instrument of experimentalism. Either vertical among the 3 levels of the federation or horizontal among the states and municipalities. And then there's a second stage in which I would call wide divergence. If part of a country applies for a right to deviate very far from the predominant solution, it can't deviate very far if the presumption is that all the states and all the provinces, all the municipalities must enjoy at the same time the same right of divergence, because then the divergence can't be radical. So in this respect, paradoxically, the unitary states have an advantage over the federal states, because in a unitary state, there's no presumption that the different parts of the state must enjoy the same right of divergence at the same time. That's why the government of the United Kingdom can negotiate a different deal with Scotland, for example, than the deal it has with Wales. And that's what I'm calling wide divergence, which obviously will have to be vetted by the political and judicial authorities to prevent it being used as an instrument of oppression. Now then, the fourth set of innovations has to do with the topic that we examined when we discussed earlier in the seminar, structural injunctions or complex enforcement, which is, in all of these societies, there's a class society, a class structure coexisting with democracy. What's the solution? The 20th century constitutions are packed with promises of social and economic rights. Unkept promises, right? And so that's not the solution. The solution is to provide in the state for a form of structural change, structural reconstruction that is localized but nevertheless structural. That's what the American judges tried out temporarily and in limited form through these complex injunctions with respect to relatively marginal institutions like prisons, mental hospitals, school systems, until they ran out of power to do this, right? So you have to provide in the state for a power specifically designed, equipped, staffed, and financed to come to the rescue of groups caught in a circumstance of disadvantage and exclusion from which they were unable to escape by the forms of collective political and economic action available to them. And that would be this fourth set of innovations. The fifth set of innovations is, instead of replacing representative democracy with direct democracy, gradually superimposing on representative democracy some of the characteristics of direct democracy. And you can do that from the bottom up, focusing on neighborhood associations and parallel structures to municipal government, or from the top down through comprehensive programmatic plebiscites about the direction of the country. So the general idea is here too, just as in the private order, you go from the details to the great projects of structural change, so too with respect to democracy. Politics, it's the same thing. You have these dilemmas which are supposedly insoluble, like this false dilemma that politics must be either cold and institutional or hot and anti-institutional, and you discover the details that allow you to resolve the dilemma, to overcome the false dilemma. And that, once again, depends on the constitutional details. Because after all, who is going to come up with something like this facility to resolve the impasse by calling early elections? I mean, this would be like the constitutional lawyers. In a country like the United States, the constitutional lawyers are occupied with the task of reimagining the Constitution, right? Because they can't change the Constitution by changing it. They can only change it by reinterpreting it. And then this idealization of the Constitution has this tilt toward the reinterpretation of rights and away from the reconstruction of structure. As I said in an earlier class, you can pretend that that equal protection means one thing rather than another thing, or due process means one thing rather than another, but you can't pretend that the Constitution provides for 5 branches of government when it says that there will be 3 branches of government. So the actual setup of the state is impossible to reinvent in this form. And therefore what prevails in American constitutional law is this reimagination of the constitutional order. That's why they say, for example, that Yale Law School is a shrine to the 14th Amendment with a library attached to it. Yes.
Just a question on federalism. Like, I was wondering, so the sense in which you talk about federalism is this idea that particular parts of a country can do different
Can
experiments.
diverge, yes.
Exactly.
And so let me just say one more thing. So this is related to the strategy of development. Take a country like Brazil, for example. We can't have a national strategy of development in which the strategy doesn't touch the ground of reality by taking a different form with respect to the major regions of the country. Because the regions are radically different. The Amazon and the far west, the northeast, they're like different planets. And the only way in which you can have a development strategy is if you rethink the future of the country in the light of these different regional realities. And that's why this experimentalist federalism is of such vital practical importance.
Yeah, so I see the importance of it like this. And I'm also linking this with what you said earlier about identity, in the sense that the ambitious project is for people to build identity with shared purposes and looking into the future. But as happens with a lot of federal systems in divided societies, the solidarities at a subnational level often happen at the level of language and regional culture. I mean, we see this in Canada, but also in India for that matter.
Yeah.
Brazil, well, there's one dominant language, relatively speaking. In India, there's so many languages, for example. So it's like the same institutional detail which allows for subnational autonomy, allows for people to do different experiments. How do you ensure that the kind of experiments that they do is like future-oriented and open-ended in this purposive sense, as opposed to retrogressive and kind of creating exclusionary majorities, but at the regional level?
I think the main answer, you can ensure it, is a simple answer.
Yeah.
There's no assurance, but I think what you do is you change the attitude to difference into cohesion, you say. How do you create cohesion? You create cohesion by having different people do things together. Common purpose is the source of cohesion, of a future-oriented cohesion. And that relates to the basic discussion about nationalism in the world, right? Because you could say there are 3 positions. So the liberal idea is that difference is a problem. And so you need some neutral framework to arbitrate among difference or to combine difference. So now we have these nations in the world, and they are experiments in different ways of being human. And so there's this poisonous character of contemporary nationalism. Nations wanting to be more different, even as they become less different. That is, they have the will to difference, and the will to difference is aroused in the context of the waning of actual difference, an impotent rage to be different. And with respect to this phenomenon, there are then 3 responses. So One response is the response of liberal cosmopolitans. Suppress difference. The nations of the world should converge to the same set of best practices and institutions, and the differences will be purely cultural or folklore, which will float over this institutional convergence, like, but will have no deep expression in the way of life, because that depends on institutions. Then there's the response of regressive, autarkic nationalism. Restore the ancient differences. Memory, right? I think the superior solution of the democratic experimentalists is equip the nations of the world with the institutional and cultural instruments to create new difference. Because difference is the solution, not the problem. If the difference is tangible, it becomes subject to compromise. It's porous. What cannot be compromised is the intangible will to a difference that is disappearing, because that can only be the object of an intransigent faith. So that's the position which we should seek to establish. But I think that these abstract doctrines, in the end, always depend on the detailed arrangements which we're able to produce. So we come back to what I think is the central theme of all of our discussions in the seminar, which is the crucifixion, right? The ideals and interests or ideas of ourselves are nailed to the cross of the institutions and practices that represent them in fact. And the law, I keep saying, is the site of this crucifixion. So that's where we have to resolve the problem, not just at the visionary level, but at the level of the practical details. And so that's why I can't resign myself to the situation that they're not doing that, right? They're discussing how to interpret the 14th Amendment, the Supreme Court case of this or of that, not the future of society. All right, have a good break. And we'll have a few weeks after the spring recess to discuss all these projects.
If we, encourage sharing out and have like one or two slides up there with a diagram.
That's fine.
I can coordinate something.
Yeah, you can just talk to the technician from media service.
Yeah.
I think, you mean like a PowerPoint or something?
Something here, I'll show you, something, just thinking like a single slide,
In general, I think a visual aid to a narrative.
Can be, yeah.
It can be, but I objected when I was in the government, we were using PowerPoint script crap.
Oh, yeah? It can be a design tool.
So when I was working on the map,
Sure.
I prohibited the
Good. It warps your thinking.
to avoid discussion.
That's right.
So
That's right, exactly. Yeah, we'll give you more. As I'm ironically going to show you some slides. Sorry, just, okay, there you go. I'm going to use it in like, something very simple, like how can we change the color that I see, basically just like make certain terms clear. Okay, great, thanks.
Sorry, Professor, just one thing.
Hey, thanks, I appreciate it. Thanks, likewise.
It's not very easy to
See you in the 24 hours.